Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come here this morning for what is known as an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case that you have in this court. The case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are your most serious type of offenses, whereas your misdemeanor are referred to as petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about the facts of the case, as well as the possible punishment that a person can receive for being convicted of the offense. Now, the case that you have in this court is a misdemeanor offense. Felony offenses are divided into 5 categories. And I'll start at the top and work my way on down to the bottom. You have a capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. Now, if you are convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, a fine up to $10,000. If a person is convicted of a third-degree felony, the range of punishment minimum 2 years to maximum of 10 years in the state penitentiary, and a fine up to $10,000. Person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine up to $10,000. Now, if you're convicted of a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type of punishments because, as I mentioned earlier, you have a misdemeanor offense in this case. Now, misdemeanors are divided into 3 categories, and we'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, your Class C misdemeanors are cases that are handled in the JP court or the city court, and they come to this court if a person is convicted, and then they appeal their case, and so then the case comes to this court. Now, the punishment range for a Class C misdemeanor is a fine only. It's a fine up to $500. Cannot be given jail time. It's a fine only. However, if you fail to pay the fine, or if you fail to complete the community service, let's say you had community service, your fine was converted to community service, and if you fail to either pay the fine or the community service, then the court can file what is called a capias pro fine. It's a warrant for your arrest to sit out the fine. You could pay the fine or you could sit out the fine in jail. Now, the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or a fine from $0 to $2,000, or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, you may qualify for probation. There are 2 types of probation. One type of probation ends with a conviction on your record, The other type of probation does not end with a conviction on your record. Now, the first type of probation that ends with a conviction on your record is known as adjudicated probation. We call it regular probation. It's adjudicated probation. With that probation, right from the start, you have a conviction on your record. However, there is something that is called judicial clemency. What that basically means, the law can allow the judge to set aside the conviction. And the way it works, or in order for a person to qualify, that is, the person has to complete the probation. They cannot have any more time left on the probation, and they have to be successfully discharged off of the probation. Once those three things happen, then the court can set aside the conviction. And if the court sets aside the conviction, then you won't have a conviction on your record. However, if you commit another offense, we say if you commit a subsequent offense and you're convicted of a subsequent offense, then the case that you receive judicial clemency on can be resurrected, brought back up, revived, and used against you. And if you try to get a license with CPS, CPS could either deny giving you a license, or if you have a license, they could either revoke or suspend that license. Now, the other type of probation, the first type was adjudicated probation. The second type of probation is unadjudicated probation. So basically, by definition, it says you have not been adjudicated. In essence, you have not been found guilty. And so you do not have a conviction on your record. And if you successfully complete the unadjudicated probation, the case will be dismissed. It would not result in a conviction on your record, and you may qualify for what is called a non-disclosure. Basically, what a non-disclosure is that the government, we cannot disclose to the public that you were on probation for this offense. We can't disclose that. However, the state or the government can have access to it. We just can't disclose it to the general public. But the state, police departments, universities, any governmental agencies can have access. And there's a laundry list of agencies that can have access in the Code of Criminal Procedure. Now, the paperwork that you have on the clipboard, I'm going to go over that with you right now. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. And basically, it speaks of one of the rights that you have. Now, as a defendant, you have rights. One of the rights that you have a right to have an attorney. Okay? And that's what this document is talking about. It states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you can represent yourself. Now, in order to represent yourself, you have to waive or give up. That's what waiver means. You're giving up your right to be represented by an attorney. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. If you want an attorney and do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out a financial, we say it's a financial questionnaire. The financial questionnaire is the second document on that clipboard. And it basically says it's waiver of counsel for purposes of entering a guilty. No, the second, no, it's the third, should be the third document. The second document is the waiver. Now, if you want to speak to one of the prosecutors, we have two prosecutors who are here in court, they're sitting at counsel's tables. If you want to speak to one of them about your case, you cannot speak to them if you are represented by an attorney. Your attorney can speak to them, but you cannot. Now, if you are representing yourself, which means you waive your right to have an attorney, and you're representing yourself, you're actually acting as your own lawyer, then you'll be able to talk to them. However, before you can do that, you must first fill out the waiver of counsel for purposes of entering a guilty plea or proceeding a trial. And so let me do this. Now, that first document, if we go back to that first document, it states that you may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Now, that's if you want to represent yourself, but be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to waive your right to have an attorney, you may change your mind at any time and may request that an attorney be appointed to represent you. At the bottom of that document in bold letters, it states defendant's choice. Mark initials next to only one choice. Now, if your choice is to hire an attorney, you will place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left, and then you write the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney or request that an attorney be appointed to represent you, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney, that is, give up your right to have an attorney to represent you, and you desire to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date, January 9th of 2024. Now, for those individuals who will be waiving their right to have an attorney and will be representing themselves, you would have to read and sign the next document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding a trial. And it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily. Voluntarily means that no one is forcing you to do this. You're doing it of your own free will. And it says that and intelligently made. Intelligently means that you know what you are doing. Furthermore, I have been advised this 9th day of January of 2024 by the County Court at Law number 2 of Jefferson County, Texas, of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed to me free of charge. Understanding my right to have counsel appointed to me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive, which means to give up. I hereby waive my right to counsel. I hereby give up my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, January 9th of 2024. Now, on the document that is titled Jefferson County Affidavit of Indigence, you will have to fill out the first page. It has your name, your address, your date of birth, phone numbers, cell, work, family member. Now, if you receive any types of benefits such as Medicaid, you would check that box. Or if you receive SSI, you would check that box. You receive SNAP, you would check that box. You receive TANF, you would check that box. Or if you live in public housing, you would check the box that says public housing. Now, if none of that applies, then you will not check none of those boxes. Now, if you're employed, you check the box that says yes, and then it asks where, you state the name of the place that you're employed at, and it's also you have to describe the type of work that you do at that place of employment and the number of hours that you work each week, and you also state how long have you worked there. Now, when it says marital status, you're either single. If you're single, check the box single. If you're married, check married. Or if you're divorced, check divorced. If you're widowed, check widowed. Or if you're separated, check separated. And if you are married, you write the name of your spouse. And the next set of questions asks if you have any children 18 years old or younger. And if you have children 18 years old or younger, you'll write their name where it says name of dependent, child or children, and then you'll write their age or their ages. Now, when it asks for residence information, it asks whether or not you rent a home, it'll be yes or no. Will you own a home? Yes or no. Reside with family members? Yes or no. Or if you're homeless? Yes or no. So you only have to answer one of those boxes, whichever one applies to you. So if you own a home, you do not rent it on, so you just circle yes. All right. Now, when it asks for monthly income assets, okay, it asks monthly, what you make a month. That's, and the first question is, my take-home pay is, whatever your take-home pay is, you'll write that next to that $sign. If you have a spouse that works, whatever her take-home pay is per month, you write it there. If not, you just place a zero. If you don't have a spouse, you just place a zero. If you receive child support, you write that. If you don't, put a zero. If you are receiving food stamps, you're gonna put that amount. Or if you have Social Security / disability, you put that amount there. Now, if it doesn't apply to you, then you will just circle zero. And if you receive any type of other governmental checks or benefits, and you place it in the category that says other government check or other income. Now, if you have any assets, a car, a house, etc., you can just write the value there. And then at the bottom, what you do is total the monthly income and assets at the bottom. Now, on the right side of that form at the bottom, it says monthly expenses. If you pay rent or mortgage, you're going to write that amount next to the $sign. And where it says utilities, electric, gas, water, you'll put that amount, your month. We're talking about what you pay per month. Now, if you have child expenses, now if you're paying child support, that's one expense. Or if you're doing other things for your children that are expenses, you're going to write that there as well. Food expenses, what you're paying for the household per month. Transportation, I'm going to get to transportation. We're not only talking about what your gas is, but we're talking about, well, like if you're paying a car note, if you pay car insurance, your car maintenance, all of that's transportation cost. Now, if you do not have an automobile, if you're paying somebody to drive you, if you're paying for public transportation, transportation or Uber or cab or whatever mode of transportation that you have to pay for, and you're going to kind of average that up per month. And for example, if a person is saying paying Uber $50 a week, right? And we'll just say 4 weeks, that's like $200 a month. Now, if you have a cell phone bill or home phone bill, you're going to place that next to cell phone/home bill. And if you're paying any type of probation fees or parole fees per month, you will place that amount next to the dollar sign. Now, if you have medical expenses or health insurance on your job that you have to pay for, you're going to place that where it says medical expense and health insurance. And minimum monthly credit card, if you have a credit card and you're paying a minimum amount of money, you want to place that amount there. And then once you get all of that, all of these categories filled, then you will just total it. Now, on the second page, where it says defendant's oath, you will have to read and sign your signature where it says defendant's signature and the day's date. Now, where it says only one selection below to be completed, you're going to go to the unsworn declaration by defendant. And then you will fill out your name, your date of birth, your address, and then it says country, that's USA. And it says, I declare under penalty of perjury that the foregoing is true and correct, executed in, it'll be Jefferson County, because it's the county that we're in, on the 9th day of, and the month is the first month, and the year is 2024. And that, once you finish filling out that part, that's it. You don't have to fill out the bottom or the third page, because that's for the court to fill out. Now, as a defendant in a criminal case, I mentioned that you have a right to have an attorney. You also have a right to have a trial by jury. Now, when those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all of the evidence, listen to all of the arguments. They will deliberate, and they will decide after deliberating whether to find you not guilty or guilty of your charge. You also have a right to waive or give up your right to have a trial by jury. By waiving or giving up your right to have a trial by jury, what that means is you will not have a trial by jury. By you not having a trial by jury, your case will come before the court in one of 3 ways. One way it can come before the court is by way of a bench trial, by way of a trial without a jury. A bench trial is a trial before a judge only. The judge will listen to the evidence, listen to all of the arguments, and then the judge will decide or define you either not guilty or guilty. The other way that your case can come before the court is by way of an unagreed plea bargain agreement. Now, an unagreed plea bargain, first of all, a plea bargain agreement is an agreement that you worked out with the district attorney or the state to settle your case. We call that a plea bargain. Now, if you're unable to work out a plea bargain agreement with the state, we call that an unagreed plea bargain agreement. So you don't have an agreement. And so when you don't have an agreement and you still want to settle your case, then your case will come before the judge. And then the judge will set the punishment within the punishment range. Whatever that punishment range is, the judge will set the punishment. Because you've been unable to work out an agreement to agree on a punishment with the state, but you're going to come before the judge on an unagreed plea bargain, and the judge will set the punishment. The other type of plea bargain is called an agreed plea bargain agreement. That means that you and the state have agreed to settle your case for a certain amount of punishment. And if that is the case, then the case will come before the judge, and the judge can either accept or reject the plea bargain agreement. Now, if the judge rejects your plea bargain agreement, if the judge said, well, I'm not going to follow that plea bargain agreement, then you could tell the judge, well, since you're not following the plea bargain agreement, I want to take my plea bargain back. I want to take my plea back. In essence, I'm not pleading guilty. I'm not pleading no contest to this charge. You can do that. Okay. If the judge does not follow the plea bargain agreement that you have agreed with the state. Now, if the judge does follow the plea bargain agreement, and if you decide within 30 days, you say, well, I think I've been wrongfully convicted, or the state has committed an error by convicting me, I would like to appeal my case. In order for you to appeal your case, when you say you want to appeal your case, I want to have a higher court to look at this case to see if I was wrongfully convicted or whether or not the court committed an error by convicting me. In order for you to appeal your case, if the judge follows the plea bargain agreement, you have to get permission from the judge who followed the plea bargain agreement. Now, if the judge gives you permission to appeal your case, then your case will go upstairs to the third floor to the Ninth Court of Appeals. They will review your case. They will decide whether they could either grant or deny your appeal. If they grant your appeal, they could simply find you not guilty, or they could send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to another court, a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals, which is located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review, and I'll explain that. Pro se means you are representing yourself. You will not have a lawyer assisting you to file this petition to the Court of Criminal Appeals. And so the Court of Criminal Appeals can do one or two things. They can either grant or deny your petition. If they grant your petition, then they can simply find you not guilty. Or they can send the case back to the Ninth Court of Appeals, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your petition, then at that point, your conviction will stand. Okay? Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court. Witnesses, basically, they're the individuals who will sit in that chair that we call the witness stand, the chair with the microphone, and they can either testify for you or they can testify against you. If you represent yourself or if you have a lawyer representing you, then you can ask them questions. Your attorney can ask them questions. Or if you represent yourself, you can ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. Waiving your right or giving up your right to have witnesses to come to court to testify simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case that they have against you. Now, you also have a Fifth Amendment right against self-incrimination. That is, you have a right not to testify against yourself. The state can't force you to take the witness stand. They can't call you as a witness. If you invoke your Fifth Amendment right against self-incrimination. Now, if you do not invoke your Fifth Amendment right against self-incrimination, and if you waive or give up your Fifth Amendment right against self-incrimination, then that means that you will be taking a stand. Now, the other thing is that You also have a right against what we call you have a right to have what we call discovery. Discovery, I guess the term discovery is like you have a right to see the evidence. Okay, if you've seen it for the first time, you're discovering what the state has against you. And so you have a right to have discovery. In essence, you have a right to see the documents, witness statements, your statements, police reports, lab reports. You have a right to view video, right to view or to listen to audio recordings. You have a right to look at any instruments. They may have, if a case involved a gun or something, you have a right to examine the gun. So you have a right to have access to the evidence that the state will be using against you. Now, you can also waive or give up your right to have discovery. By waiving and giving up your right to have discovery, that just simply means that you will not be having access to the evidence that the state has against you. Now, as a defendant in a criminal case, as a defendant in the case that you have, obviously you're here today, you were arrested, you bonded out of jail, you either got out of jail on a cash bond, which would mean that you paid the full amount of the bond to get out, or you're out of jail on what's called a surety bond, which means that you paid a bondsman a percentage of the bond to get out, or you're out of jail on a PR bond or personal recognizance bond, which means you didn't have to pay any money to get out of jail. You were released under your own personal recognizance with a promise to appear in court. Now, I said that to say this. Every day that you spent in jail on your case, if you spent 1 second in jail, that's considered 1 day. You spent 1 second, bonded out, you booked in, bonded, and booked out, that's considered 1 day. Or let's say you they booked you in jail at 11:59 p.m. and you got out at 12:01 the next day, 2 minutes later. That's 2 days. Okay, so they go by calendar days. It's not 24 hours. Okay, so it depends on how many days, the number of days that you spent in jail can be used as credit toward your punishment. So, for example, let's say you spent 5 days in jail, bonded out. You're here today, and you and the state have worked out an agreement to settle your case, and the state is offering you to serve 5 days in jail. You already served 5 days in jail. You won't have to serve any more time in jail because you have been given credit. You can be given credit for time served. Okay. The other thing is if you and the state have reached an agreement that you will pay a fine. Now, every day that you spent in jail, you're credited at $100 per day that will go towards your fine and your court costs. So, for example, you spent 5 days in jail, that's $500 that can go toward your fine and court costs. So if you and the state have worked out an agreement for you to pay a fine and court costs of $500, you spent 5 days in jail, then you won't have to pay $500. Why? Because the time that you spent in jail has already paid it off. Therefore, your fine and court costs will be taxed and retired. That's what we call it. Now, if you spent 5 days in jail and the state is offering you 7 days, then that means you'd have to do 2 days. Now, if they're offering you a fine and court costs $700, you spent 5 days in jail, that's $500. That means you have to pay $200. Now, you have to pay $200 on the day that the case is disposed of. However, if you cannot pay the fine, then if the court finds that you are indigent, then the court can convert your fine and court costs to community service, which means that you can do community service to work it off. Now, every 1 hour community service that you perform, $12.50 will go toward your fine and court costs. So in essence, if you work 8 hours community service at a nonprofit organization, that's $100 that will go toward your fine and court costs. Now, Jefferson County has a program for first-time offenders. So let's say you haven't been in trouble before. And they have a program that is called pretrial diversion. With the pretrial diversion program, the state will dismiss your case and you can get it wiped off your record. The way it works is as follows. It has to be your first time getting in trouble. It cannot be an offense for unlawful carrying a weapon or resisting arrest. And you would have to have an attorney to assist you at writing the application to get into the program. And as I mentioned, if you get into the program, case can be dismissed. And if you complete the program, it can be expunged, which means erased, deleted, or wiped off from your criminal record. And if you're interested in that, just let us know. And then we'll direct you to the person that you need to talk to, or we can give you the forms that you need to get in order to get into that program. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County has a program that is called Veterans Court. And this program, as I mentioned earlier, is for veterans only. Now, as with this program, once you get into the program and complete the program, the case will be dismissed, and you can get what is called a non-disclosure. A non-disclosure means that we can't disclose to the general public that you had this case. Okay. Now, as I mentioned earlier, when I talked about non-disclosure, governmental agencies and places like that can have access, but the general public, which is most of the people, cannot have access to it. And in a few minutes, we're going to have Lori, who's going to come and talk to you about the Veterans Program and also some of the other added benefits that the Veterans Program has. Now, Jefferson County also has a program. Well, this court has a program that is called the CSI program. It's a program that I started within the first 100 days of taking office. That's a program that is designed to address the issue of recidivism. Recidivism means that people commit crimes continuously or over and over. And so how do we stop it? Well, we stop it with the CSI program. And with the CSI program, we have partnerships with agencies in our local area. One of the partnerships that we have is with the Spindletop Center. Spindletop is our local mental health center for this region. With Spindletop, what they'll basically do, they'll have they're able to have a private interview. They're able to have an assessment, develop an assessment, and also they're also able to develop a treatment plan for either outpatient or inpatient treatment. Now, you do not have to be incompetent or insane to participate in the program. This program is designed for individuals who just merely may suffer with depression or anxiety or any other host of other mental illnesses. They'll be able to address those. And then Spindletop, they're going to come to you in a few minutes, and they're going to talk to you about the program that they have to offer as well. Now, Spindletop also have a program that is called ATAR. It's a drug and alcohol recovery program. And we also have a partnership with the local Drug and Alcohol Council as a program that is called OZAR. Both of those programs are programs where they will do an assessment. They will do an interview, and then they can develop a treatment plan, either outpatient or inpatient treatment. We also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas that you select, then they will assist you at getting a job in the area that you are trained in. If you have not graduated from high school and you would like to get your GED, then they also have a program at Lamar at CICE, in the CICE program. They have a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you do not cost you anything. They are free. In fact, the only thing they may cost you is time. And in this court, we do not just give time, we take our time. And we believe that if we take our time, it's better to not just arrest the problem, but to address the problem to prevent it from happening in the future. Now, I like to tell people this all the time. When you come to county court at law number 2, we do not have court as usual. We have unusual court. And it's not because we're different. It's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, then we'll make a difference in our community, because what comes out of the home goes into the community. And so with this program is designed to produce productive people. And we believe that if we produce productive people will not commit crimes. Why? Because they have too much to lose. So if you're interested in any one of these programs, just let us know. And then we have brochures, and then we have people here who will be able to talk to you about some of the programs that we have. So at this time, I guess we'll start off with Lori, and she's going to come to you and tell you something about the veterans program that they have to offer. Lori?
And I'm with the Military Veteran Peer Network Program, and we help our veterans find resources in the community. Do I have anyone here who has served in any of the armed forces? Oh, good. Anyone here who is married to someone who served in the armed forces? But after this lot of information, I will be reaching out to you, and then we can put it together, correct? You said. And I've been reaching out to you. We can help you seek mental counseling. We can help you access your benefits that you deserve, you earn them. And we have a program we can possibly assist with some financial concerns that you might have. Does anyone here have a child that is currently serving or has served with the military? Or a parent that is inside the household? Okay. So when you fill this out, once again, I'll be the one who will be contacting you. My name is Lori. Do you have a pen, sir? Yeah, okay. And this will not be any type of verbal calling. I will not sell it for their information. People know me. I'll reach out to talk to you. And we'll just keep a check on you. We'll contact you every few months and see how you're doing. Okay.
I just help you with my diet.
I'm sorry?
I just help you with my diet.
Well, it will not help with your please. But are you receiving medical care from the VA?
I don't have a doctor yet. Trying to get mine. I don't go to the VA.
Right.
I don't ever help. But
We can walk in.
which one goes? Well, they killed my friend. I don't have to go there now.
Okay.
Yeah. It's on a problem, they killed him, so I don't even go there no more. I need to. Take care of myself.
Any other concerns or questions about the Military Veterans Peer Network Program?
Okay, at this time, we're gonna have someone from the Spindletop that's gonna come and talk to you. We got Deputy Hinton and Gabby. Y'all gonna come forward and they're gonna tell you something about the program that Spindletop has to offer.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state and commissioned here with the sheriff's office. I'm here with my coworker Gabby. Now, Gabby is a qualified mental health professional. The Spindletop. The reason we're all here this morning is because the judge has graciously invited us in his courtroom because he cares about every single person who comes before the bench. What the judge has found and what statistics prove is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you with your particular situation. Excuse me.
Sorry, when we mean mental health, we can mean just anxiety, it can be some stuff like sadness, depression, stuff that it doesn't help being in the court, because we know life goes on, bills have to be paid, resources have to be met, relationships go on with kids and stuff like that. We understand there's needs that need to be met, and anxiety can increase in depression. So very common stuff, but we also understand that's not easy at all.
Now, maybe this is your first time to be here, maybe it's your 10th time to be here. There's still hope. In fact, what we're offering you today has the ability to change your life, but we're going to need something from you. And Gabby's going to explain what we will need and how you can do that very privately.
So the paper I gave you when you walked in, that is very important paper for me. It's protected, so the only person who's gonna get any of that information is me. You're gonna receive a text from me initially. If the text doesn't work for you, just let me know and I can give you a call if you'd like. This only allows me to contact you once in a matter of choosing. That's it. It's not a robocall again, it's gonna be from me. It's just gonna ask what resources you need, if there's anything I can help you with, is there any needs, even if it's just support, we can help you with that also. But it's really important that you give me a good phone number for that, and, if you'd like to talk a little bit today, just let me know. There's a checkbox on the bottom of that, just check that, and I can just, maybe I can talk to you privately, don't want to embarrass you or take any more of your time that you are in the court, so just want to interrupt any of the court process.
Also, before you leave here today and we pick up those forms, we'll also hand this out to you as well. It's a brochure. It tells you a little bit about the advantages of participating, but it also has a 1-800 number on there. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. Now, what's about to happen is the court is going to go into recess, and when it does, we'll be able to come out there and we'll visit with you. We'll pick up those documents from you, and I'll also hand this out to everyone so that everybody has this. Thank you very much.
Yeah.
Thank you, Your Honor.
Okay. Thank you, Deputy Hinton and Gabby. Now, ladies and gentlemen, the paperwork that you have on the clipboard, we're going to pick that paperwork up from you. If anybody needs any assistance with filling out the paperwork, we have our court personnel who's here who will be happy to assist you at filling out the paperwork. Now, it's going to take us a few minutes to gather the paperwork and then to assist individuals who need assistance. So if anyone needs to use the restroom, there are 2 restrooms that's right outside in the hallway. The men's restroom is next door in front of County Court at Law number 3. The women's restroom is on the opposite side of the hall in front of the 172nd District Court. Okay? Now, do not leave the courthouse, because if you leave the courthouse and we call your case and you're not here, then your bond may be forfeited. If your bond is forfeited, a warrant will be issued for your arrest. Okay? And so we're going to go into recess right now. And then I think some of the folks from Spindletop and the Veterans Program, they're going to come out and talk to you while we're in recess. So at this time, the court will be in recess.